Good morning, Your Honors.
Good
David
morning.
Hall on behalf of Plaintiff Appellants. I'd also like to reserve 3 minutes for rebuttal, if I may.
All right.
This case concerns claims under the Securities Act of 1933 that were properly commenced in state court. Under that statute, the Securities Act, there's a provision that's explicit and mandatory that gives plaintiffs an absolute choice of forum. It bars any removal of claims like this that were properly commenced in state court. Mandatory, absolute, no discretion to the parties, no discretion to the court. Once commenced in state court, these cases stay there. Defendants removed anyway. As pretext, they point to the bankruptcy of a non-party and then point to a discretionary removal provision in the bankruptcy code that doesn't say anything about these types of cases. Doesn't mention the Securities Act, doesn't say that it was intended to override the Securities Act, nothing about the Securities Act. That's not how it works. We know that from Supreme Court opinions going back decades. We know that from Radzenauer. We know that from recent decisions from the Supreme Court, like Epic v. Lewis that we cite. We also know it from this court's decisions, controlling decisions. Luther is the case that we point to because it concerns the same removal bar under the Securities Act, but there's a wealth of opinions. Courts don't pick and choose between statutes. They don't infer an implied repeal on nothing more than the say-so of counsel. Implied repeal, allowing one statute to override another without an expression of it in the statute, is extremely rare. It's disfavored. It doesn't come up very often. That's for good reason, as explained by all the authorities that we point to. And there are several requirements that the party proposing that extreme medicine must satisfy before we even get to the sort of secondary canons of construction that defendants have, led the district court to accept.
So there's one circuit decision, the WorldCom case from the Second Circuit, that disagrees with you. What are your main disagreements with WorldCom?
Thank you, Your Honor. So WorldCom was, a two-judge motions panel, didn't have full briefing, didn't have the benefit of this full appeal. But it's also plainly wrong. It misinterpreted the canons that it did apply, specificity and surplusage, and I will explain why. But it also skipped the threshold step. The parties there didn't have, I wasn't in the case, but they didn't argue the irreconcilable conflict threshold issue under Radzenauer, Epic v. Lewis. So it jumped ahead. It assumed the parties there assumed there was an irreconcilable conflict and then engaged in those secondary canons of specificity and surplusage. Here, we haven't waived those arguments. It's front and center, and we can't skip that threshold step.
But do you agree there is a direct conflict? You've got Section 22A saying you cannot remove to federal court, and then 1452A that says for bankruptcy proceedings you can remove where there's jurisdiction, bankruptcy jurisdiction.
Well, the question isn't conflict at all. I mean, all these cases have conflict. It's irreconcilable conflict, and the Supreme Court and the Ninth Circuit have given courts the tools to reconcile statutes like this. One line of authority from the Ninth Circuit that we cite says where one statute is mandatory and the other is permissive, the permissive should give way to the mandatory.
Well, WorldCom found there's exceptions to both, right? So Section 22A has an exception for class actions, and then Section 1452A has its own carve-outs. So why is that incorrect? If you're, teeing up exceptions on both sides, why should we favor one versus the other?
So once you get to the specificity canon that I think WorldCom is speaking to there, and it's sort of avoiding the specificity canon because it says, one statute is not a complete subset of the other, so they're both equal. We'll move on to other canons. That's a misapplication of the specificity canon. We know that from Radzenauer itself. There were exceptions to both of those statutes. There wasn't a complete overlap. The National Bank Act wasn't a complete subset of the Securities Exchange Act and vice versa. Mm-hmm. We also know that since WorldCom, the Supreme Court has rejected that misapplication of the specificity canon. We know it in Radlax, which we cite. We know it in M-Corp, which also involved the bankruptcy removal or bankruptcy code. So that's not how specificity works. Even if you get to specificity, WorldCom got it wrong. WorldCom didn't cite anything for that.
So tell me why Section 22A is more specific than the general removal statute in 1452A.
Sure, Your Honor. It's really by any measure. The case law explains that the court should look to really all the circumstances in determining specific versus general. Qualitative, quantitative, proportional, absolute numbers. Any measure, pick your measure. It's clearly more specific. The removal bar.
It's not clear.
Oh.
It's not clear.
Okay.
We wouldn't be here if it were clear. So tell us why.
Sure.
It's
sure.
more specific.
Thank you, Your Honor. Let's start with the qualitative reasons. There's the substantive scope. One deals with Securities Act claims brought in state court. That's it. The other, the removal bar under the Bankruptcy Code, could apply to any substantive claim. Could be disability claims, could be employment claims, could be personal injury claims, could be securities claims. Any claim that has any tangential connection to bankruptcy could potentially get sucked up into that removal provision. So on their face, the substantive scope is different. Also, another qualitative difference. The removal bar under the Securities Act only benefits plaintiffs. It's only a protection for plaintiffs. The only party that can invoke it, rely on it, do anything with it are plaintiffs. The class of litigants under the removal provision of the Bankruptcy Code is unlimited. Plaintiffs can remove to federal court. Not even intervening non-parties can remove to federal court. Related parties in consolidated litigation, it's not just defendants, it's any party. You also look at the nature of the provisions themselves. One is mandatory, the Securities Act removal bar. That reflects Congress's intent that it be an absolute bar that always apply. The language is no case shall be removed. Then you look at the permissive discretionary nature of the bankruptcy removal provision. It doesn't require defendants to remove these cases. They may not. Even after they've been removed, courts don't have to keep them there. They can remand for any reason. It can be an equitable reason, it can be comedy, any reason that justice requires. We know that those caveats, those gaps, those permissive gaps in the bankruptcy statute are a feature and not a bug. We know that because the Supreme Court in Things Remembered, as we explained in our brief, looked at those and contrasted them with other mandatory provisions and said this is on purpose. That Congress passing the bankruptcy removal provisions understood that it's going to impact and come into conflict with other removal provisions. And those permissive features are meant to give way, are meant to accommodate, not displace, the other removal provisions like the removal bar.
Can a state court adjudicate bankruptcy matters?
Well, I will point out there are no bankruptcy matters in this case.
Well, I'm asking you the question theoretically. May a state court adjudicate bankruptcy matters?
Well, I think they can adjudicate some non-core bankruptcy matters.
Right.
They can't adjudicate core bankruptcy matters.
Right.
Neither are at issue in this case. And I would point out, Your Honor, that, the sort of justification.
But we're looking at the statute, so we're not looking just at the facts of this case. We're looking at the statutes because that's what you're comparing the statutes in terms of specificity, and we have to look at what the statutes are intended to do.
Right.
And so that's why I asked that question about whether or not a state court could adjudicate the bankruptcy issues.
Well, it could adjudicate some non-core bankruptcy,
Right.
and it definitely could adjudicate claims like this that have at best a tangential connection to a bankruptcy of a non-party. And we also know that Congress, in passing the bankruptcy removal provisions, put in those permissive removal and remand options, recognizing that even cases that might be related to a bankruptcy can stay there at the discretion of the parties and based on a case-by-case specific assessment by the court. So,
Do you agree that there's related to jurisdiction over these claims or no?
no, we don't agree. We contested that. The standard in the Ninth Circuit is the same as the Third, the PAYCOR decisions, and it's
Fairly permissive, isn't it?
Well, the word conceivable is pretty permissive, but when you look at the decisions that actually interpret what that means, the limit is, would it require another lawsuit, a judgment in another lawsuit to substantiate the purported basis? And here they point to indemnification and contribution rights that are really hypothetical and never come into play unless they go get a judgment. So even if those rights could suffice in some cases, they wouldn't here because there hasn't been that other judgment.
So go ahead.
So would your clients have to file a claim in the bankruptcy proceeding?
For this type of case?
Yes.
No, Your Honor. And so the connection to bankruptcy and the efficiency gains are all illusory. The bankruptcy plan has already been confirmed. Defendants, after they improperly removed us, never tried to transfer us to New York. So the idea that this was all to accommodate the bankruptcy is really a fiction. It's forum shopping by defendants. They want to be in federal court.
Well,
Plaintiffs want to be in
because
state
you were
court.
forum shopping.
Right.
I mean, everybody's forum shopping.
Yeah, and Congress gave plaintiffs the absolute choice of forum here, and we think it should be respected and not overridden by the Bankruptcy Code.
On the other hand, the role of the bankruptcy court has been recognized over and over as uniquely important. It's the one forum where all the claims against a party that has been that is declared bankruptcy or is in bankruptcy can be resolved. And allowing your clients to proceed in this competing forum, if you will, the argument is will undermine this whole carefully constructed system that recognizes that the bankruptcy removal statute is special and necessary to protect the bankruptcy court's unique competence in administering bankruptcy estates. I didn't make that up. It's right out of Wright and Miller. But how do you respond?
We recognize the importance of the Bankruptcy Code. There's a whole court system for those cases. There's hundreds and thousands of those cases every year. But we know from the statute itself, Congress, when they wrote the removal provisions into the Bankruptcy Code, specifically contemplated that some of these cases aren't going to get vacuumed up into federal court. Some of them are going to stay in state court. So that was intentional. That's a feature, not a bug, as the Supreme Court explained in Petrarca, things remembered. We also, countervailing point, Your Honor, we're talking about the Securities Act passed in 1933 in response to the Great Depression. The capital markets of the United States are also very, very important. The reason investors all over the world come to the United States to invest is because of the protections from statutes like this. This is a seminal statute. Congress, when they passed it, was reacting to maybe the greatest financial crisis we've dealt with. They specifically put in this removal bar to protect plaintiffs, to give them the strength to enforce the choice of venue so they can enforce this very important statute. So, if we're really comparing just broad brush the overall importance of these systems, I think the securities laws and the capital markets are equally important.
Let me ask this. When we think about irreconcilable conflict between two statutes, I read your briefing to read it in a more broad sense of if you enforce Section 22A, will that frustrate the basic purposes of the Bankruptcy Code? And you would say no, that you can create a narrow exception. Appellees narrow in a little bit more and say it's not that broad of a lens. Look more specifically at whether you can do two things at the same time, and you can't both remove and bar removal at the same time. So which one is right?
We're right, Your Honor. As explained, not just in our brief, but in Radzenauer. If you look at Radzenauer, which is the seminal case on this, and we think a very persuasive and instructive case, a district court case, the Alcon case, that's probably the most thorough analysis of WorldCom and how it would interact with a removal bar since WorldCom. Both of those cases explain that the proper frame is not whether the overlapping portion of the Venn diagram reaches a different result. We know that's not the case. It's not that just in this case, applying these two narrow portions of the statutes as a whole, would you reach a different result? Of course, that just states the question. We wouldn't even be engaging any of these.
Right, because in Radzenauer, you can't both have venue in only one district versus wherever you want.
Yeah, it was the same, and it was the same in this court's controlling decision in Luther. You had the removal bar, and then you had the CAF removal provision. It was either getting removed or not. That wasn't
But Luther was relying more on the specificity versus general. It didn't get into irreconcilable differences.
Correct.
Or conflicts, rather.
And I think the proper rubric is to move through the irreconcilable differences, apply the Ninth Circuit case law and minor exceptions and mandatory versus permissive before we get to specificity. But in all candor, the same considerations come up in both, Your Honor. When you look at what's a minor exception, you look at a lot of the same factors that we point to as why the removal bar is more specific. The impact, the relative impact, the proportional impact. I was trying to think of good analogy. The impact on the securities laws is there's, these cases are maybe a drop in a puddle, but compared to the bankruptcy system as a whole, it's a drop in an ocean. The proportional impact that it'll have is minor as, to the bankruptcy statute. Not as clear as I'd hoped that would come out, but if I may reserve some time.
But not all of the security cases will have a bankruptcy component, though.
Correct, Your Honor. But when you look proportionally, there really aren't that many State Court Securities Act cases to begin with. So you're talking about a puddle to begin with. I mean, I think there have been, 10 a year or something like that, there's very, very low number of cases to begin with. But then when you look at the proportion that are impacted by a bankruptcy, we do have a handful, and that handful is a substantial portion of that already small pool. When you look at the ocean of bankruptcy cases, bankruptcy removal cases, the number of securities cases that would be barred by the removal bar is negligible. It's a fraction of a fraction of a fraction of a percent. We're talking about hundreds of thousands of cases, and maybe I think this has come up 5 times in 40 years. So the proportional impact on the bankruptcy code is much lower than the proportional impact on the securities.
But when it does come up, it comes up in terms of many millions of dollars. So in each case, certainly it is impactful.
Yeah, these are important cases, and we think that, Congress gave plaintiffs the right to enforce these laws because these are important interests, and they
And they
impact a
gave
lot
the
of
right
people.
of removal. That's the problem.
Right.
All right, counsel, you've exceeded your time. We'll give you a couple of minutes for rebuttal.
Thank you very much.
May it please the Court, Dan Lerman for the defendants. WorldCom was correctly decided. The text, timing, and purpose of the statutes all show that Section 1452 authorizes removal of cases that arise under Title 11 or relate to a bankruptcy case. First, the statutes are in irreconcilable conflict. They dictate...
Did WorldCom decide that point?
Excuse me, Your Honor?
Did WorldCom decide that point?
Yes, and it did decide that, and it's de novo in any event for this Court. But WorldCom,
but
yes.
One question at a time, counsel. Point me to the language in WorldCom where the irreconcilable conflict was addressed.
It said that they were in direct conflict, and it said that you cannot comply with one and the other at the same time. That is this Court's definition of a reconcilable conflict.
Where's the language?
This is a close question as it involves a direct conflict between two unambiguous statutes. Section 22A...
What page are you on?
I'm sorry, Your Honor. This is Judge Cabrenas' decision at page 90 in the very first paragraph of WorldCom.
But later on, WorldCom talks about how, when it's talking about undue burden, that something could happen where indemnification agreements with the estate could affect or do other things. I didn't read it to talk about a conflict. It did say direct conflict, but whether it was irreconcilable seems pretty absent from this opinion.
It might not have used the word irreconcilable, but this Court has defined irreconcilable conflict to occur when two statutes dictate opposite results as to a particular matter, that's from Novak, or when one statute permits what the other prohibits, that's from Moyle. We have that here. You cannot comply with both statutes. But if you want to get, Your Honor, to
well, I guess I'll tell you how I think about this. It seems as if the problem with your case is it hasn't really meaningfully addressed this presumption against implied repeal. And it is a really strong presumption that comes up in many different Supreme Court cases and in our own cases. And I'm having a hard time seeing why the bankruptcy amendments would have impliedly repealed Section 22A. And isn't our attempt, we have to try to harmonize those statutes together before we reach that point. So how would we...
Yes.
Can you address that
Yes,
issue?
3 things. First of all, I think what the presumption against implied repeal says is that we don't presume an implied repeal unless there's an irreconcilable conflict. That's what Radzenauer said. Radzenauer first said the first statute is more specific. We now ask whether there's an implied repeal that happens when there's an irreconcilable conflict. So they're essentially synonymous. This Court has found implied repeals in Krusky, in Novak, in Moyle, in Glacier Bay. In Krusky, the first statute said that officers of national banks could be fired at will. Another statute, the ADEA, said that discrimination on the basis of age should not be allowed. This court held that the second statute prevailed because application of the first one would interfere with the scheme. And we have that here. Just to address your point about harmonization, what harmonization means is that if you can comply with both statutes, we'll try and comply with both statutes, so you won't impliedly repeal something when you can comply with both. That was the case, for example, in Stand Up for California, where there was nothing in the Indian Gaming Act that said anything about NEPA. That's the case in Epic Systems, when there was nothing in the NLRA that said anything about arbitration. You could comply with both acts, so we're not going to read something into the second act to impliedly repeal it. The second part of the harmonization point, and I think this court made this clear in both Glacier Bay and Moyle, is that when there is a conflict, we'll repeal it only to the extent necessary so that we will give effect to the second statute. So I think that's all this court is saying with respect to implied repeals.
But why can't we infer an implied exception, a narrow exception, saying, look, you can remove for bankruptcy provision, for bankruptcy cases under 1452A, except in the narrow context of Section 22A claims?
Well, first of all, those narrow exception cases, as we stated in the brief, are really just specificity cases. They're just cases where this court stated that the first statute is specific and a subset of the second. The second answer,
which we'll get to in a second,
okay.
but I guess
right.
that is a way to harmonize to statutory conflicts.
It's a way to harmonize it if you're just saying the first one trumps. You could also harmonize it by saying the second statute is a narrow exception. That's what this court said in its en banc decision in Novak. So I don't think that narrow exception question stands for some sort of independent doctrine other than the specificity doctrine, because that's just begging the question. They don't provide any reason why applying Section 1452 here would interfere with the Securities Act. The only thing they say is that it denies them an absolute choice of forum. But that also just assumes the conclusion. We know that it gives you a right of forum in some cases. The question is what happens when there's a direct conflict, as here, when another specific statute gives you a right of removal. We point to many cases, and Your Honor cited the Wright and Miller Treatise, which talks about how this is designed to protect the unique competence of the federal courts in bankruptcy matters. We cite many cases for the proposition that bankruptcy is unique. The Constitution authorizes Congress to create a uniform bankruptcy scheme under federal control. Section 1452 was designed to centralize all bankruptcy and bankruptcy-related litigation in a federal forum. We know that 1452 was meant to expand that removal authority, according to Justice Ginsburg's decision in Things United. And so this could have real damage. This case and WorldCom are examples. WorldCom, there were dozens and dozens of state and federal actions. There was a single bankruptcy case, but there were dozens of other follow-on cases that could interfere with the core purpose, which is to protect the estate and the orderly administration in bankruptcy. So Congress recognized this problem and targeted this problem. There's no problem the other way. The federal courts can vindicate someone's rights under a federal statute, the Securities Act, and that's really the only thing they say is that they have a choice of forum. But both statutes give someone a certain extent of choice of forum. The question is which would do more damage if we're getting to this repugnancy analysis. And every court to address the issue in this circuit, and WorldCom addressed it if it didn't use the word irreconcilable, has shown that we're talking about the bankruptcy system as a whole. We're not talking about one particular case. We're talking about cases that arise under Title 11 and that relate to Title 11.
Or.
Correct, Your Honor, yes. And this can have massive impact. It had massive impact in WorldCom. It's having massive impact in this case, and that's directly what Congress cared about. So I think the deleterious consequences can be significant.
And so can you explain to me the massive impact? Because, well, either we're speaking in a case-specific way or in a general statutory sense. And we haven't, I mean, it's surprising that WorldCom is the only circuit decision that's actually addressed this, and it's 20 years old. So these things don't come up on a regular basis. And WorldCom was a big, bankruptcy. SCP is a big case.
Yeah, I will say.
So it's like these odd offshoots that happen and can have reverberations, I suppose.
Yeah, I will push back a little. There have been dozens of cases in this circuit. There have been dozens of cases in the Second Circuit. They're fewer now because they have a binding precedent, right? But this did happen before WorldCom. Since then, the courts there just applied WorldCom and minimizes the conflict. One of the purposes of this.
So let me ask you this. So we have a bankruptcy proceeding. It's all the way over in New York, and here's NDCal cases. What actual impact would there be here if at the end of the day the litigation here in California would relate to resolving the securities claims and whether there's liability, and then the bankruptcy court would have to decide or some other court, whether indemnification or other contribution requirements apply and affect the estate.
Well, first I'll just suggest that, as Judge Rawlinson said, this is about the statute. It's not about a particular case. And that's it, just full stop. And these apply to cases that arise under Title 11. That includes avoidance actions and cases that might not be court proceedings but are directly related to the bankruptcy action. So it would apply. There are certain claims against the property of the estate that cannot be brought in state court. There are certain claims that directly affect the estate, and this statute targets those. Now, the purpose of targeting related to is also to protect the estate, because Congress recognized that you could have duplicative proceedings, you could have conflicting judgments. One of the purposes was to avoid jurisdictional disputes, which is what we have here. All of this could affect the estate. Just as a simple matter, even aside from conflicting judgments of law, we're depleting the estate. There are already being advanced fees under the D&O policies. That's before we talk about indemnification or contribution. We have conflicting discovery demands. That's all in this case. So it does affect the estate in this case. Also, I'll say these cases, other than this one, have all been consolidated in the federal court. That yields certain efficiencies. It protects the unique competence of the federal courts in these matters. Even if it's not transferred to the bankruptcy court in New York, we still have 10 cases here that are all in federal court. What they want is to have certain state cases that assert claims under the same act and involve the same defendants be fractured from the federal case, where you can't consolidate, you can't relate, you can't coordinate, and that all further depletes the estate, Your Honor.
Well, let me ask this. I mean, earlier I think you were essentially suggesting that this all boils down to specificity. So why do you think these statutes are equally specific and one is not more specific than the other?
Yes. I will caution that specificity is an important element of this case, Your Honor. In Radzenauer itself, the court first asked whether it was specific, and then it said, even so, if one interferes with the other, we will give effect to that. So I agree specificity is important. I don't think there's quite as rigorous or Procrustean ordering. I think, we're all getting to what Congress intended here, and that's one indication of congressional intent.
So you don't want to address?
No, I am going to address it, Your Honor. No, I am clearly addressing the issue, and I will, and I'm sorry.
Okay, so I thought I didn't hear the answer to the question.
Okay. They are both specific. What Radzenauer says is you ask whether one statute is specific and one is general. Here, Section 1452 is a targeted bankruptcy-specific removal statute. It is a specific supplement to the general removal statute, and it applies to claims that are related to a specific bankruptcy case that is in bankruptcy at that time. So the statutes here are both specific.
But what about the point that, bankruptcy removal covers a whole range of substantive law as opposed to Securities Act only claims?
I think what that shows, Your Honor, is Congress intended to grant robust removal authority over these cases. What
does that do to the specificity
right.
analysis?
Excuse me, Your Honor?
Sorry.
What does that do to the specificity analysis?
I don't think it does anything, Your Honor, because the question is whether one is specific and one is general.
Which is more specific? That's the question.
I'm sorry, Your Honor. I think it's difficult often to say which is more specific because sometimes it's apples and oranges.
I think you're resisting
No,
this
I'm not,
question.
Your Honor. I don't mean to resist it. They are equally specific here, Your Honor. This is tethered to a specific bankruptcy case.
But you need to tell us why they're equally specific. You're saying that, but you're not explaining to us why in the statutory schemes they're equally specific. Because,
Your Honor, Section 1334 either talks about claims arising under Title 11, which is a specific thing. That's like a fraudulent transfer or an avoidance question. Those were created by the bankruptcy law, by the bankruptcy code, which was comprehensive federal jurisdiction over all of bankruptcy law in the United States of America, and those can only be brought under the bankruptcy law. That is just as specific as a Securities Act claim. Even as to related to claims, that is just as specific because it's targeted. It has to be related to a specific bankruptcy year case, Your Honor. A specific bankruptcy petition is very
But any number of different things can come up under bankruptcy, any legal matters.
That's
whereas
right.
Securities Act claims
areas.
of 33, and then you deal with the parties. One of them only relates to plaintiffs being able to remove versus all parties. So though that also seems more general than the Securities Act.
I disagree, Your Honor. If you look at Radzenauer, the first statute in Radzenauer applied to a particular defendant, national banks. The second was a general venue provision that applied to anywhere the defendant was located, the defendant did business, or the act was violated. So you had one apply to a specific defendant and one you applied to a national bank. If it said plaintiffs or defendants, that wouldn't have changed it. It would have still been a specific plaintiff or defendant. And again, the whole purpose here of the removal provision was to expand removal authority. The mere fact that it applies to plaintiffs or defendants does not make it less specific. It makes it more robust, and that is consistent with the congressional scheme here. So they were both specific statutes.
I'm not sure I understand that. I mean, the intent to remove, and I don't think anyone's doubting that there is an important premise behind the intent to remove for bankruptcy matters. There is also an important premise behind wanting to bar removal for Securities Act claims. How does that relate to questions of scope between the statutes?
Well, I'm just saying
Congress wanted to do both. We're trying to find out if Congress intended to impliedly repeal or limit the earlier statute.
I'm just saying it goes to congressional intent. If you look again at Krusky, Your Honor, you could say that claims by or against national bank officers affect a very small proportion of all cases or all employment discrimination claims. But precisely because it was such a targeted absolute statute, that is why this court found a conflict, and that's why this court resolved the conflict in a later statute, because it conflicted with Congress's scheme over employment discrimination. I think that's analogous to the case here. So the mere fact that it is robust, that's consistent with the ADEA, which is also robust and applies to a broad variety of claims.
Why doesn't Luther help guide us? Luther also addressed a broad scheme, CAFA removal, which has a monetary threshold and some diversity requirements, but otherwise you can remove any number of different kinds of claims of class actions under CAFA versus Securities Act.
May I answer, Your Honor?
Sure.
Of course.
Okay, thank you. Luther addressed a different statute. Every court in this circuit to address the issue has held that Luther does not control. The reason why, and that includes Luther itself on remand. Initially, the district court found no jurisdiction under CAFA. This court agreed. On remand, it applied this court's decision in Luther and said Luther is different. The reason why is what CAFA did was it relaxed the complete diversity requirements for diversity jurisdiction with respect to large class actions. That is a procedural mechanism. This is not a procedural mechanism. This is a targeted bankruptcy-specific statute that Congress enacted as part of—
But Radzenauer was also a procedural mechanism. That we're talking about scope. And whether it's a procedural mechanism or not, CAFA allowed for a broader scope of claimants to come before the court in removal. Then I don't understand why procedural would make any difference as to a scope.
Well, it's not targeted to any specific subject matter. It's still targeted to bankruptcy and a particular bankruptcy petition in cases arising under Title 11, which is a whole chapter of the United States Code devoted to bankruptcy cases. That's not true for diversity jurisdiction, Your Honor. So I think it is different, not just because class actions are a procedural mechanism, but because diversity jurisdiction is different than a specific grant of federal question jurisdiction in 1334 enacted as part of the Bankruptcy Code. I think that is distinguishable. Luther also didn't address whether Section 22 would interfere with the application of anything, but it certainly didn't address whether its removal bar would interfere with 1452 because it didn't address 1452. It also didn't address this place in the statutory scheme, including the absence of the except as otherwise provided language, which we believe shows Congress's intent that Section 1452 would control in all cases except for the two enumerated exceptions therein. So Luther is distinguishable. Every court to address the issue has held that Luther is distinguishable. That includes Luther itself on remand. And so we believe that WorldCom and Judge Cabranes' decision there was correctly decided and that this court should follow RUCOM and affirm the decision below.
Any other questions? Thank you, counsel.
Thank you.
We'll give you 2 minutes for rebuttal, counsel.
Thank you, Your Honors. So Luther provides the roadmap if the court wants to engage the specificity analysis. It's a controlling decision. It addresses the same removal bar. And the CAFA statute that was compared to the removal bar in that case is not materially different from 1452 here. So it also lacked the surplusage language from 1441. It also applied to a broad scope of substantive claims. And the Ninth Circuit had no problem applying the specificity analysis, comparing the removal bar, holding that the removal bar was specific and that CAFA was general and broad. So specific doesn't equal subset. That's what we got below. That's what WorldCom said. And that's what my opponents argued pretty much up until today. But we haven't heard much about the subset, that specificity is only applicable if it's a subset. They've seemed to abandon that argument, and that's, that's accurate. WorldCom got that wrong. We know that because of Luther. We know that because of Radzenauer. We know that because of the intervening Supreme Court cases like Radlax and M-Corp. Also on whether WorldCom addressed irreconcilable conflict, it did not. Direct conflict is not the same as irreconcilable conflict. The definition that because the two statutes would lead to a different result in a specific case, that does not mean that the statutes can't be reconciled. We know that from Radzenauer, which explicitly says that, that the statutes lead to two different results in a certain case is not enough. That just states the question. The court then has to try to reconcile the statutes, and we have those tools. We have the tools spelled out under the minor exception cases, and I would point the panel to Judge Rawlinson's joinder in the dissent in U.S. v. Novak. Now, the result in Novak turned on some language that isn't present here. There was a notwithstanding any other law clause that overrode, that was interpreted by the majority to support an implied repeal. But Judge Fletcher's dissent that Judge Rawlinson joined goes through the minor exception doctrine, cites the same cases we do. And that is all sound analysis. The result may have turned on a different.
But it didn't carry the day.
Yes, Your Honor. But it turned. The result turned on language that isn't present here. We think that the balance of that analysis should carry the day here. I'd also like to point out that a misstatement, the idea that all the cases are in federal court now is just not true. There have been some related cases that have been remanded back to state court. The entire bankruptcy regime did not crumble under the weight of those cases in state court. We also have a split. So since WorldCom nationwide, there are cases on our side of the ledger that have held that the securities removal bar trumps the bankruptcy removal provision. Those cases were sent back down to state court. But we didn't have the sky is falling bankruptcy impact on the bankruptcy regime that has been alluded to in this case. We also have the impact here. The bankruptcy plan was approved. We have cases proceeding in state court, other cases that were remanded. We have our case that has not proceeded to discovery. It hasn't been consolidated with the other security cases. None of the securities cases have been sent to the bankruptcy in New York, but the bankruptcy plan proceeded fine. It got approved. It didn't have an impact on the plan. So whether you look at the impact on the statute of the whole or you look at the actual impact in cases like this, the sky is falling parade of horribles that we hear about, the bankruptcy, it just doesn't materialize.
All right. I don't think we're looking at it as a parade of horribles. We're just looking at the statutory scheme and which one Congress wanted to be more intact. That's the difficult question for us. It's a very challenging case. And we thank you both for your helpful arguments. The case just argued is submitted for a decision by the court. That completes our calendar for the day. We are in recess until 9:30 a.m. tomorrow morning.
Thank you, Your Honor.